Good morning to you all, and it's a great pleasure for me to introduce my colleagues, Tabang Rapuleng and Michael Yates, in our division, Employment Law, and in order to take you through some important developments and most recent cases from our labour courts, dealing specifically with selection criteria in retrenchment matters. But before I start with my own presentation, I want to just alert you to one possibility. You will be appreciative that under the Labour Relations Act, an employer must apply agreed upon selection criteria, and in the absence of agreement, to apply criteria that is fair and objective. So, as far as possible, it would be best to try and reach such an agreement, but a component of that agreement should include how personal and private information may need to be managed. And why do I say that? Because in these types of processes, it can happen that one is examining the poor performance, or rather I should say performance ratings of employees, disciplinary records and the like, and you do not want to be trapped in a situation where there's over-processing of personal information to the detriment of employees because they haven't consented to that. An example that I can point to occurred with regard to a major German retailer in it was in Germany, where there had been such an over-processing and the employer ran into difficulties under the General Data Protection Regulations and was heavily fined because private information that had been taken by way of surveys was misused, and it was misused in a manner where poor performance ratings became a common issue in workplace considerations, and of course the necessary protection was not in place. So that's a point I would like just to highlight to you this morning. What we need to distinguish as a kick-off point today is our labour courts distinguishing between retrenchments caused by a need to cut costs by reducing staff and a different situation where there's a dislocation of incumbents on effective posts in a restructuring exercise, where the very aim of the exercise may not be to reduce staff numbers, as you would have understood in relation to the first example. So how do our courts deal with this? Well, we have a decision of Lowe versus SAB. And what happened in this particular matter is that the employee was employed by South African Breweries as its sales manager in George. Owing to a restructuring of the business, his particular post was going to become redundant. What they wanted to do was eradicate the sales manager position and add other functions to it. So the new post was to be pitched at a much higher level of management. So, in view of that decision, SAB invoked Section 189 of the LRA. And interestingly enough, this is what it said would be the selection criteria for the best candidate in relation to this new position. And they said as follows: they would be taking into account the best candidate for the job, taking into consideration skills, historical performance ratings, qualifications and experience and length of service. So of the three that applied, Mr. Lowe was unsuccessful. He was outflanked by a much better candidate for that new role. And then it left him somewhat stranded as a dislocated or displaced employee. He declined a vacant position in Port Elizabeth. He declined to apply for that. He didn't believe that that is what would suit his particular skill set, and he declined to apply for a position in Aliwal North. And as a consequence of that, he was retrenched. One of his gripes in the Labour Court was that poor performance ratings were taken into account because his ratings were substandard. But he'd never appealed those ratings. And although he succeeded in the Labour Court in demonstrating that there was a level of unfairness with regard to the selection criteria applied in this instance, the Labour Appeal Court found quite differently. If you do not appeal a rating that you're dissatisfied with, then you must live with that. But of course, the issue in this matter is that Mr. Lowe would not and was not told that down the line, a poor performance rating could be held against him in the competitive process of selecting the best person in a revised and renewed job in the organogram. So I found favour with the Labour Court, not being particularly satisfied with that, believing that Mr. Lowe should have had an opportunity to at least have had a say about that poor performance rating before it was taken into account against him in that selection process for the vacant job, the new position that had been created in the organogram. But of course, an employee may not wish to take issue with a poor performance rating at a particular point in time because they've taken a decision. In the next year, I'm just going to show that I'm really worth my salt and I'm going to put my shoulder to the wheel. He is denied that opportunity if, in fact, it's used against him in a subsequent retrenchment exercise. And that's where I think one needs to be careful. But of course, what the Labour Appeal Court said in this particular decision with regard to Lowe is the following. These particular criteria that were taken into account to assess the person's ability for the new post, i.e. the performance ratings, qualifications, experience, and only then length of service, are not necessarily the criteria one would use to select an employee for retrenchment when that competitive process for vacant positions is complete. So it's almost a two-step process. So you look at criteria for the appointment of the person to a post, and when that is concluded and where there are persons who cannot be accommodated elsewhere in the business, it's at that point you look at selection criteria for retrenchment. And those must be, as I said, either agreed upon first, or the employer must ensure that those are fair and objective. Now, in another decision of some interest, Zeda Car Leasing and Avis Fleet versus Van Dijk, which is a very recent judgment last year, the problem stemmed from two managers who were not getting along. And although the employer started the process of incompatibility correctly by endeavouring to facilitate a process to try and have these two managers get on, when that process failed, the employer decided, we'll go about this a different route. We'll demolish one of those two managerial roles. We'll simply merge the one with the other. These two managers are the only persons to apply for the role. And if there's one that doesn't get the position, that's the person that's selected for retrenchment. Now, the Labour Appeal Court obviously said the employer had gone wrong, in the sense that it should never have invoked a retrenchment process in the face of incompatibility, but rather completed an incompatibility process, because we know that that's a ground for dismissal under the species of incapacity in the Labour Relations Act. So what the court was saying is that the requirement that employees compete for a post is not in itself a method of selecting for dismissal. And that's the point that I really want to home in on, because when I hand over to Thabang, that is the issue that he's going to be managing in terms of the most recent decision of the Labour Appeal Court in the Telkom matter. And I would like to hand over to you, Thabang. Thank you very much.
Thank you, Fiona, and good morning, everyone. So as Fiona alluded to, I'll be dealing with the Labour Appeals Court judgment in the case of Telkom SA SOC against Van Staden and others. That is basically judgment dealt with the selection criteria, and I think we all know that the selection criteria must be fair and objective, and one of the most widely accepted selection criteria is LIFO. However, in this judgment, the court was dealing with a selection criteria called non-placement, or what has been termed as using non-placement as a selection criteria. And the court considered whether non-placement as a selection criteria for retrenchment was fair and objective. In essence, according to the Telkom's selection criteria, it was the fact that someone was not placed into an alternative position that placed them at the risk of being selected for retrenchment. So that's the criteria that was being used. And just briefly, the background to the entire exercise. In 2014, Telkom embarked on a large-scale restructuring exercise, and they termed it a fit for the future. And as a result of that restructuring exercise, 100 employees were retrenched by Telkom. Section 189 notices were issued to employees. The selection criteria was a process of applying for positions, and it had 3 phases. If an employee was not placed, they were at risk of retrenchment. Now, how it was done, affected employees were required to identify vacant positions to apply for in the new structure. And we will discuss I'll deal with the selection criteria in detail, but in a nutshell, what it entailed is that employees were required to submit an expression of interest form. They were then allowed to apply for roles at their current level or one level higher or one level lower. And then qualifications and experience was considered for the during the placement process. Now, let's look at the placement process that was used. Firstly, it's important to note, and this comes into play when one understands the reasoning of the Labour Appeals Court, that there was an establishment of panels. A placement panel considered the suitability of employees for the 3 roles they were interested in. So employee will have to identify 3 roles, and a placement panel will consider their suitability. Then there was also what they termed an assurance panel, which ratified the placements to ensure compliance with the set criteria. In a situation where a number of employees had applied for and qualified for the same position, LIFO then was applied in selecting the successful candidate. That would be a situation where let's say 2 employees qualify, they have the same, they meet the requirements, they qualify for the same position, then LIFO was then triggered in that particular situation. So the application of the placement process took place in 3 phases, as I alluded to earlier on. Phase 1 was a placement panel was established, and its duty was to consider the suitability of the applicant against the job specifications. In this particular phase, only affected employees were allowed to apply for vacant positions. The employees were placed on the strength of their experience and qualifications. And it's important to note, and this is something that the Labour Court took issue with, that there were no interviews that were conducted. The exercise basically involved using job descriptions and specifications for each post against the experience and qualifications of the employee. The employees who were not placed by the end of phase 1 were entitled to lodge an objection, and thereafter an appeal could be lodged. So there were 2 processes. You could lodge an objection and you could lodge an appeal, and this is something that the Labour Appeals Court took into account as well as when we deal with the Labour Appeals Court. Then there was phase 2. In phase 2, employees were not successful in the appeal. They were allowed to apply for the remaining vacancies in phase 2. This was now basically a second bite of the cherry for those particular employees. During phase 2, the requirements were relaxed and they were not strictly applied. So these will be the minimum requirements. They were relaxed and they were not strictly applied. For example, if initially During phase 1, the requirements was that you must have 5 years experience. During phase 2, they will consider even someone with 4 years experience. They were released. So, but the vacancies, the pool of vacancies was now smaller because some vacancies were filled during phase 1. And those employees who were not successful in phase 2 were allowed another chance in phase 3. Then phase 3 operated in this way. Employees competed amongst themselves as well as the public for the remaining positions, because it basically means for this particular position, we could not find a suitable candidate in phase 1, no suitable candidate in phase 2, but now the competition becomes even broader in that you're now competing with the outside candidates. And this was the last stage of the selection criteria. Those employees who were not successful in all the 3 phases were then retrenched. Ultimately, 100 employees who were affected and had not been placed into any alternative post were retrenched. This included the respondents in the case who were retrenched in October of 2014. Now, aggrieved with their retrenchments, the employees referred an unfair dismissal dispute to the Labour Court. At the Labour Court, the employees challenged, in essence, the fairness of the selection criteria. They alleged that they had been identified and selected for retrenchment before consultations began. The Labour Court found that making employees apply for available positions was unfair, and that even if this was not so, the method that Telkom used to decide placements was applied unfairly. The Labour Court specifically took issue with the fact that no interviews were held and that no objection and appeal processes was available at the conclusion of phase 2 of the process. You will recall that the objection and appeal were available during phase 1. The court held that the selection criteria was subjectively and inconsistently applied. Also, the Labour Court was also unhappy that members of the placement panel did not testify at the trial to justify the decisions that were taken during that particular process. The court found that although life or last in, first out would have been a fair selection criteria, it was not applied. As a result, the court found the decision not to appoint the respondents into any position was unfair and found that their retrenchment was therefore unfair. This matter was appealed to the Labour Appeals Court, and from the onset, the Labour Appeals Court distinguished between 1, the placement of an employee into a post during a restructuring exercise, and a selection of an employee who has not been placed for retrenchment. So the court says we must distinguish between those two. 1 deals with the placement of an employee into a post during a restructuring exercise. Then the second one deals with the selection of an employee who has not been placed. It says those are 2 distinct processes. The court held that although the exercises are related, they are not the same. The court found that the criteria for placement and selection criteria for retrenchments are different, and the former is not converted into the latter when an employee is not placed. Essentially, the court held that placement criteria is not a substitute for a selection criteria. What is the difference? One is a competitive process, and the other is a selection of employees for retrenchment. So the placement process is a competitive process because a number of employees are vying for 1 vacancy. The competitive process will obviously consider the relative strengths and weaknesses of the candidates. Then the selection process itself, this concerns the application of a selection criteria, which is either agreed or is to be fair and objective if it was not agreed to during the consultations. So the Labour Appeal Court noted that if there is a legitimate operational requirement for a restructuring exercise, an employer may request employees to apply for placement into positions during that restructuring exercise. However, the process of placing employees into position will be subjected to court scrutiny. The court is required to consider whether the process put in place and the decisions taken in terms of the placement process by the employer were fair. With regards to the fairness of the Telkom's non-placement criteria, the Labour Appeals Court held that the placement process had been subject to extensive consultation and had been applied consistently to all affected employees. While the placement process did not allow for interviews, it did permit employees to submit extensive written motivations in support of their placement and retention. And the court also took into account that employees could object and appeal against an unfavorable decision taken against them, and also that the placement decisions were taken by a panel and then referred to 2 individual committees for verification and approval. Employees who were not placed were considered against substantially relaxed criteria for placement in the second phase. That will be employees who were not successful during the first phase. Employees, and then the court found that in this particular case, the respondents did not exhaust the internal remedies available to them, as only 4 objections were raised, 1 of which was withdrawn and only 1 appeal was lodged. So during the entire process, only 4 objections were raised to those panels, and there was only 1 appeal which was later withdrawn. Now, the court then held that such mechanisms provided the opportunity to rectify scores, reasons to be given for decisions taken, or any errors or irregularities that might have occurred. The result was that having failed to exhaust such internal remedies available to them, the nine of the employees were unable to show that by the end of the first phase of the placement process, the selection criteria had been applied unfairly against them because they did not make use of the objection process and the appeal process in essence. Now, Telkom was able to objectively justify the non-selection of the remaining employees who had lodged an appeal. There was no evidence before the court that the employees' non-placements were made on an unreasonable or arbitrary, subjective or inconsistent basis. Accordingly, the Labour Court found that there was nothing unfair about the selection criteria or its application. So Telkom was not obliged to propose further selection criteria for retrenchment after the placement process had ended. And there was no reason advanced by the respondents why Telkom's selection criteria was neither fair nor objective. And there was nothing per se unfair in a process considering its scale. In essence, the Labour Appeals Court confirmed that the non-placement of an employee pursuant to a placement process is a valid selection criteria for retrenchment. This is provided that the process itself is fair and objective, and its application is also consistent. It is therefore advisable that when adopting non-placement as a method of selecting employees for retrenchments, employees are provided with internal remedies or mechanisms such as the internal objections or appeal mechanisms. Because as one will have seen, the Labour Appeals Court placed weight on the availability of those mechanisms and the employees' failure, the respondents' failure to make use of those. These remedies must be geared towards providing immediate and cost-effective relief and allow for any irregularities to be rectified speedily. And quite importantly, the court basically was not in favor of the Labour Court's criticism that Telkom could have used LIFO. The court says it was not for the court to decide which criteria Telkom should have used. The essence was that the court was supposed to satisfy itself that the criteria that was used was fair and objective, and it found that the criteria was indeed fair and objective. So this is quite a development in dealing with selection criteria. Fiona, thank you so much. I will be handing over to my colleague, Michael Yates.
Hi, good morning, everybody. Okay, so I'm going to be dealing with a slightly different theme in terms of what we are discussing currently in terms of retrenchment, because I'm going to be speaking about a scenario which most employers may find themselves in, particularly given the fact that we've seen a dramatic revolution over the last couple of years in the workplace, and employees have not only just become more flexible, but they are also willing and able to actually be productive and work way beyond the age of retirement. So for this reason, many employers opt to keep the very experienced and knowledgeable employees on even after they've reached the retirement age. Most employment agreements provide that a person who is on permanent employment and after they've reached the age of retirement, their employment contract would actually come to an end. And any subsequent employment thereafter, whether it's on a fixed term basis or otherwise, would be regarded as a new period of employment. Now, this is generally seen as the start of a new fixed term contract. However, in February this year, the LAC had an opportunity to examine exactly this scenario and to consider such a situation in light of a retrenchment and the calculation of the severance entitlement that an employee would be entitled to after he had attained the age of retirement. So I'm going to discuss the matter involving Barrier versus Paramount Advanced Technologies. And the LAC, or the Labour Appeal Court, had to determine the meaning or interpret the meaning of having a break in one's employment. Now, this deals with an interplay between various sections of our Basic Conditions of Employment Act, more notably sections 41.2, 84.1 and 84.2 of the BCA. And as you may well know, section 41.2 deals with the severance provision, dealing that an employee may or is entitled to a retrenchment package of 1 week for every completed year of service. Section 84 deals with the meaning and the calculation of the severance pay by providing that if there is a break in service of less than 1 year, that break will not be taken into consideration for the purposes of determining one's length of service. And then, of course, section 84.2 provides that any payment that an employee had received during a previous period of employment must be taken into account when determining further payments to the employee. Now, these benefits must be taken into consideration in terms of section 84.2, and that is exactly the question that the court had to determine, because what happened in Mr. Barrier's case is that after he had retired, he had attained the age of 65, he continued with his employment with his employer in a smooth or in an unbroken manner. And essentially what had happened is that he was then retrenched 4 years later after having attained the age of retirement. Now, basically what the employer wanted to argue was that because Mr. Barrier had received certain retirement benefits at the age of retirement, that ended his previous period of employment, and when he commenced or continued with his employment after retirement, he started a new period of employment, and therefore when he was retrenched some 4 years later, the employer tried to argue that he was only entitled to 4 weeks of severance instead of 32 weeks as claimed by Mr. Barrier. Now, the Labour Appeal Court stated that the question to be answered was whether there was an actual break in his employment and whether Mr. Barrier was entitled to severance in respect of the earlier break, or the earlier period. The LSC held that the break contemplated in section 84 was in fact a time lapse and not necessarily a form of contract. In order to determine his entitlement, one had to consider what was the period of employment and to what severance he would be entitled to when taking into consideration his length of service and any other payments received. And the LSC held that a long-serving employee does not necessarily lose his entitlement to severance pay, even if he did at an earlier stage qualify for retirement benefits. In other words, if an employee had been retrenched and paid severance and rehired, then that payment would be taken into consideration if the employee would be retrenched at a later stage. However, if an employee had benefited through gaining some form of retirement benefit at the age of retirement and continued working, that would not necessarily mean that the employee would not be entitled to his full duration of service. So the Labour Appeal Court concluded that the severance pay is an additional payment to which an employer pays an employee and is meant to soften the blow of unemployment and is distinct from any benefits which the LAC held did not constitute monies that an employer would take into consideration when calculating a severance benefit at a later stage. So in short, the Labour Appeal Court held that there was no break in Mr. Barrier's employment. They awarded him 32 weeks of severance, which amounted to slightly over R1 million for Mr. Barrier, fortunately for him. But the lesson in the matter is in short that an employer must note that this is a potential risk if it does continue to employ its employees beyond the age of retirement, and it should put the necessary mechanisms and safeguards in place to ensure that if there is a retirement or a retrenchment rather at a later stage, that it's not caught in this net where the LAC quite clearly said that you still take the full length of service into consideration. So thank you very much. That's it from my side. I don't know if anybody has any questions to answer.
I think we hand back to Thabang to address a question.
Thank you. So the question is basically what is the difference between the objection process or the objection process and the appeal process. So within the Telkom judgment, the objection before, when one lodges an objection, basically you are lodging an objection to the placement panel against their decision not to place you. And that objection was before the chairperson of the placement panel. So it will be for the placement panel then to go back to the scores and and how they assessed the selection into that particular vacancy and satisfy themselves whether they're happy or not. Then obviously if the chairperson of the placement panel was satisfied that they've done everything correctly, then they will then confirm that indeed you are not placed. Then the employee had an avenue then to then appeal. Now, unhappy with the objection, you can then appeal and then it will be taken to the appeal panel. And the appeal panel was chaired by an external chairperson. And the employees were then afforded an opportunity to appear before the appeal panel, and they could even make use of a representative in appearing before the appeal panel. And the appeal panel obviously then will have to then look at the entire process to check whether are there any irregularities that were committed, are there any errors that were committed. But at the end of the day, the appeal panel will then justify, will have to be in a position to justify the non-placement of the employee or to overturn it. But obviously in this particular case, we don't have an example where it was overturned because that process was not utilized by the employees. So that was the difference, where the appeal panel is now before an external chairperson, and it's the final decider on that placement or non-placement of that particular employee. If one was unhappy with the decision of the appeal panel, obviously the only recourse now will be to go externally. So that's how it was used within the Telkom restructuring exercise. I hope that I've answered that particular question as well. I'll hand over to Michael. I understand there's a question for Michael as well.
Yeah, fantastic. Thank you, Thabang. There is one question. It reads, if there are positions available after the selection process and you are now considering making reasonable offers, what do you take into account for the offers to be reasonable? Now this is a very difficult question to answer, because at the best of times, the question on whether an alternative position is reasonable is a value judgment that is made by the parties. Usually what is taken into consideration would be the impact that it would have on the employee, whether this is a demotion or not, and whether it would be unreasonable for the employee to decline that particular position. As we all know, if an employee rejects a reasonable alternative to retrenchment, the employer can in fact retrench that employee without a payment of a severance. Now, the impact of the latest COVID pandemic, as we all know, and the situation that our economy is in, may very well play some factor on whether an employee is expected to accept a reasonable alternative or a position which is significantly less than what he or she had previously occupied. But at the end of the day, I think what is considered to be of vital importance is whether the acceptance of a reasonable alternative would cause any form of undue hardship on the employee themselves, such as, for instance, having to relocate from Johannesburg to Cape Town, for instance, because what you would take into consideration is the effect that it would have on that employee's spouse. That employee's spouse may, for instance, still be employed in Johannesburg, or the fact that they have to uproot their kids and move them from a school in Johannesburg to Cape Town. Also, the fact that the income may be significantly less would also be factors to be taken into consideration. So it's very much determined on a case-to-case basis. I'll also just move to a second question, which reads, how does one avoid, sorry, let me just read this question. A person at retirement age who continues working for claiming severance for the whole duration of employment. So the question is, how does one avoid it? Firstly, probably the one distinguishing factor that we saw in the barrier case is that there was no real clear break between the previous employment and the new employment period. For instance, Mr. Barrier, after having reached the age of retirement, walked back into his office and into his workplace the very next day and continued seamlessly with his employment. If there is, for instance, if you do find yourself in a situation like that, what you can do in order to up the employer's chances of successfully arguing that there are two separate periods of employment is to conclude an agreement with the employee that upon retirement, his contract has come to an end completely, and that severs the previous employment, and conclude a new separate agreement with the employee, and you agree specifically with the employee that this will constitute a new period of employment. That may, under certain circumstances, tip the scales in the employer's favour. I see that there is one more question that I will just read out loud. How does one introduce a retirement policy where an employer has none or there is no normal retirement age by way of practice? Well, firstly, that is done as you would introduce any other policy by drafting up the policy, communicating it to the employees and providing an implementation date. However, retirement age can be quite a tricky thing, so we would highly recommend or advise that it should form the part of the process of consultation with employees if this is something new that you're going to introduce in the workplace. I don't see any further questions. I think that is it. Sorry, there is one more question, Kirshka, if you'll allow me. What are the examples that employers may adopt to safeguard against challenges which may come about after extending or offering contracts of retirement? Then again, I think the same, it is based on a case-to-case basis. I think the trick there is just to make sure that your intentions are clear and that those intentions are recorded in contracts that you conclude with the employees after them attaining the age of retirement. So thank you very much. I think that's it from my side. I've also been asked just to end off the seminar, and I would like to thank everybody for your time this morning that you've set aside to join us here. We really hope that you found these sessions to be informative and helpful. if any of the topics that we've addressed strike a particular chord with yourself, please feel free to reach out to any one of our attorneys to help you along the way, and we will look forward to hearing from you. So we would like to say thank you and goodbye, and be safe. Cheers.